Minister. Minister, to continue the debate on this bill, the genesis of this bill arises, unfortunately, not from new politics or even reform, but actually from the worst kind of grubby old politics, from a deal done with undue haste to satisfy a pet project of an independent minister who seeks to hold the government hostage. His particular hobby horse, to which the government have unashamedly bowed down to, in fact, for the party of the state that claims to be the party of the state, the genesis of the state, the party of Collins, O'Higgins, Cosgrave et al. One wonders to what new low they are now prepared to stoop to remain in power at any cost and allow the government to shuffle on toward the summer recess. Indeed, Minister Ross's crusade on the judiciary is reminiscent of the worst excesses of the jingoistic Little Englander Brexit Yellow Press. The Yellow Press, as my grandfather called them, the Tory papers. Such papers had an anti-judicial assault during the Brexit debate. Daily Mail had a front page festooned with pictures of Supreme Justices named and shamed, as they put it, enemies of the state. There was shock, horror and indignation. One of them even spoke a continental language amongst the rabid culture of the Brexit debates. Unfortunately, this kind of anti-electoral tyranny appears to be at the heart of this bill. Having been kept at bay, thankfully, for close on 12 months because of probably wiser minds in Fine Gael prevailed, despite the coalition promises, I believe, in the formation of government, the bill is now advanced following the recent scandal. But the shocking speed at which the bill is now being tabled, at the expense of all other business, and as an opposition, a first-time term TD who has been trying to submit legislation and private members' bills and trying to work through the system to have things even taken to first stage, it is shocking to see the speed at which all other business has been disregarded, cast aside. 19 hours, I understand, this week, possibly more next week, so that one single hobby horse of one independent minister can take centre stage above all else and be tabled. That undue haste is only matched by the unseemly speed at which the Taoiseach sped to the park, at least metaphorically, previous Sunday, to prevail upon him to fast-track the appointment of the former Attorney-General in order to cover his and the government's blushes at this having continued. It is also notable that the Minister for Transport, whose bill we all know this is, in his own department, has actually only published one piece of legislation since taking office. As my colleague said a few moments ago, the Minister for Stepside Garda Station, perhaps, but certainly not the Minister for Transport, because we are seeing problems across the transport world in terms of creaking park and rides, lack of investment in the motorways, the entire Greater Dublin area is suffering from the commuter infrastructure or lack of. I had PQs to the Minister yesterday. I was surprised to see very little substance again. Well, not surprised because I'm accustomed to it at this stage, of substance emerging. The Greater Dublin Transport Area Plan has been produced and has been forgotten as quickly. So perhaps the Minister would be better advised to concentrate on his own department. The one piece of legislation he did introduce, the Road Traffic Bill, I had to prompt the Taoiseach during order of business before Christmas to remind the House and to remind the Government that actually those provisions were long overdue, because the Clamping Regulatory Bill had been introduced in 2014, but it took 2016 and in fact 2017. And as I say, I did raise it with the Taoiseach eventually in December 2016 to ask when would these regulations ever be enacted, or when would the sections be enforced, and that has thankfully commenced, but it took some prodding to actually make that happen. So that is in stark contrast with the speed and passion in which this bill is being pursued. Also, one is reminded of old politics in the sense that Deputy Jim McCallaghan, and it is certainly the case that Fianna Fáil do see the need for change in the judicial appointment system. We are open to that suggestion. We are open to reforms. Deputy McCallaghan proposed a very detailed, thorough and considered bill and has been working on it for some time. Many other deputies in this House across all sides, certainly in the opposition benches, there has been cross-party support and interest. Many deputies have spent time finessing amendments, proposed amendments to that bill, none of which ever actually got off the ground. Because the bill, and I say unfortunately the government, falling back to the worst kind of old politics, found that there was a money bill, and there was a measure of charge on the Exchequer, which meant it could not progress. I think the money charge was actually slight, but nonetheless it was used as an excuse by the government to avoid dealing with the substantive matter until now, when, as the Minister Ross has successfully brought this back upon the agenda. I do wonder even now, when the government has effectively admitted its error in the handling and procedures used in the recent appointment of the Attorney-General to the Court of Appeal. I wonder now, will the government concede and will the government agree that an apology is due to the 3 High Court justices who were overlooked, disregarded, ignored, who had made their case clear to the Attorney-General, and we understand that the Taoiseach was aware, but which proceeded no further. Would the government even have the good grace to issue an apology to those 3 High Court justices who went through the correct procedures, the correct channels, and yet their cries fell on deaf ears? I would think an apology would be welcome. They did everything right in terms of applying through the Appointments Board and informed the AG. And while that appointment may have been within the letter of the law, it certainly was not within the spirit of it. We have seen repeated and substantial calls from senior judiciary, from the Bar Council, from eminent judges, judicial experts, experienced commentators in recent days, all offering stark warning as to the advancement of this particular bill. Yet it appears, and again as per the worst successes of Brexit, that we have had enough of experts. The likes of the President of the Supreme Court, the Chief Justice, the President of the Court of Appeal, the President of the High Court, the President of the Circuit Court, the President of the District Court are all to be disregarded. We have had enough of experts. Their joint letter to the Taoiseach, an unprecedented step. The government has refused to engage, has refused to publish, will not engage on it. It's a first in legal history. The substantive concerns raised in that letter, I say, are unprecedented in the history of the Irish state, and yet the government is determined, well, at least some members of the government, we have heard welcome concern raised from government benches in recent days, but they are determined to press ahead. Minister Ross knows better. It's reminiscent of when the government attempted a power grab on Dáil committees not so long ago. At that point, they were forced to go to the people with a referendum. 7 former Attorney Generals signed a letter at the time, published a letter in the Irish Times. 7 former AGs, warning against progressing in that regard. The government proceeded regardless. They had enough of experts. The same pattern we're seeing again today. Thankfully, on that occasion, the people put a brake on the government's advance. The mandate of the people was sought. The ballot box said no. They said enough is enough. And they rightly put a halt to the gallop of that power grab. In the same way as an attempt on the Shannon was made shortly afterwards, and that was also, again, put a halt to by the people who respect the separation of powers, who respect the houses of the Oireachtas, even if perhaps the government may not always do. Tuesday night, we heard how the most fundamental layer of local democracy was also whipped away by the last government when town councils were abolished by Minister for the Environment at the time, Phil Hogan, a move that at least the Labour Party, who are a substantial part of that government, have had the good grace to admit regrets upon and express their concern. They had the courage to do so. And yet the government, the Fine Gael, the Fine Gael party who continue in government, have had no such Damascene moment and have not considered yet the error of their ways. The Taoiseach recently spoke in this House. He spoke about a book club, and he spoke about books he might recommend over the summer recess. One of those books was Hillbilly Elegy. It's a good read. Read it recently myself, J.D. Vance, and it was one of the Taoiseach's favourites. He regaled us with tales of it. But I'm not sure if the Taoiseach has read it yet. Maybe he'll read it on his summer break, because if he had read it, he surely would have learned from it a tale of a dysfunctional society, of fake news, of a distorted value system, a distorted value set, and the sort of dysfunctional anti-establishment, anti-intellectual frenzy that ultimately elevated President Trump to power. And yet it is the same sort of cowboy crusade that the government now appears engaged on against the judiciary. Continuing with the book club theme, I consider another volume, Kelly on the Constitution, a seminar work known to law students for decades, probably the most authoritative work on the Irish Constitution, littered with references to judicial independence, to the importance of the independence of the judiciary, respect for the office, respect for the Chief Justice, respect for the state. At one point in the book, he suggests that any attempt to interfere with the system of judicial appointment will be unconstitutional. It is notable that the late John Kelly is a former occupant, or was a former occupant, of the seat now held by Minister Ross. The late John Kelly went on to serve in the Fine Gael government. He was a deputy for many years. He was a minister. He served as Attorney General, and he is an extremely eminent and distinguished legal academic. Could he ever have foreseen the day that his own beloved party, the Party of Law and Order, the Fine Gael party that he served so well, would turn around and basically cast aside his thoughts and volumes and all that decades of legal thought behind it? Turning to the substance of the bill, the concept of a lay panel and a lay chair, the anti-judicial bias. There is no evidence that this is required or necessary. The evidence, in fact, from people like Dr. Owen O'Malley, who published research in just April of this year, just 2 months ago, there's no evidence at all to back up the contention that political appointments, or that appointments that are politically influenced, have any bearing on the exercise of functions of the occupants of same, on the performance of a judge. And actually it compares in stark contrast to the United States, where we do know that there are Senate hearings and appointment hearings and ratification hearings which are highly politically charged, and there are Supreme Court vacancies kept open for years, in some cases, with, say, Justice Scalia, where no appointment is made because the partisan tensions in the House are so extreme and so great that there is that no agreement can be reached. We have not seen that system in Ireland. That has not been the case. In actual fact, evidence would suggest that the Fianna Fáil government certainly reached across the floor in every sense and appointed many judges who may not have been from the same political persuasion. And in fact, the academic evidence confirms that. I say Dr. Owen O'Malley's recent paper confirms that the appointments detail actually have no bearing on the performance of duties as a judge. We do not have this kind of politically charged, highly partisan approach to the judiciary as may occur in some other jurisdictions. It's not the United States. It's not a partisan culture. Ruan McCormack, who again we had, I think, referenced earlier today, the Supreme Court performed a study going back over 80 years of jurisprudence, of judiciary, of evidence, of decisions. In his article in the Irish Times, I think it's either this morning or yesterday morning, he said if one was to design a piece of legislation, this would not be how to do it. That's Ruan McCormack, an expert in the Supreme Court. But we've had enough of experts. Again, no evidence of any type of success or any kind of persuasion. I would tend to think if it's not broke, don't fix it. But perhaps the government, or Minister Ross, knows better. If we consider the international experience across the common law world, we are part of the common law judicial system. Another reason why it is imperative that judges follow within the ranks and follow a certain procedure, because that is how law is made. The common law system, the system of precedent, of stare decisis, that is exactly how these decisions are arrived at. But across the common law world, if we compare ourselves to other jurisdictions, if we look at New Zealand, New Zealand is considered to be the country with the greatest degree of freedom to the state and to the government in terms of judicial appointments. How they conduct their appointments to the judiciary within New Zealand is the greatest freedom in terms of the government having the most latitude. And yet, it's ranked #1 for judicial independence and judicial integrity. #1. Ireland is actually, despite much claims and much debate to the contrary and suggestion, primarily from Minister Ross and supporters of this bill, Ireland is ranked #4. It's not bad, #4. And in England and Wales, the system which probably is closest at the moment in the common law world to the system Minister Ross wants to introduce is ranked #6. Now, it's top 10, but it's certainly far behind Ireland, and it's far behind New Zealand, who have no such system in place. It does not lead to better outcomes. But this kind of obsession with the lay majority, this kind of idea that nothing but a lay member will do, the language is wrong. The concept of judicial versus non-judicial is also very, very unclear. And certainly there is a gratuitous disregard for the Chief Justice. In actual fact, it would appear the languages and the judges are targeted in this legislation are excluded, forced into minority position. And it appears to be a form of perverse logic, that they're precluded by virtue only of having professional expertise in the field in which they're asked to consider. They're excluded for knowing something about it, because we have had enough of experts. It is wrong, certainly, for any appointment to be made on the basis of political bias, but it is equally wrong to suggest that a politically involved individual should be excluded from any elevation or career progression. Indeed, we have heard talk of King's Inns, and I'll return to that in a moment. Much talk of that in the last couple of days, but it's worth considering some of the political alumni from that institution. You can look at Wolfe Tone, Robert Emmett, Daniel O'Connell, Patrick Pearse, C.J. Haughey, Gareth Fitzgerald, Mary Robinson, Mary McAleese. That's just to name, what, 7 or 8? The concept that a political appointee is somehow to be excluded from consideration for judicial office is a nonsense. The most eminent politicians, statesmen and leaders of this state have many have served, have graduated from King's Inns or from the Law Society of Blackhall, because the two go hand in hand. The practice of the law, the practice of politics have so much overlap, so much interest in the Constitution, in the way the state functions, in the way the state works, that the type of individual that pursues one invariably pursues both. And that is normal across the Western world. If one was to analyse, in fact, why there may be difficulties in appointing judges, or why judicial appointments have had some difficulties, maybe it's less to do with the system and more to do with the reality that the attractiveness of judicial office has been diminished in recent years by the government in many ways, in practical ways, such as pension entitlements in terms of salary. There's often very little sympathy because people don't like to talk about politicians or judges or holders of senior office, but the reality is they are experienced, qualified people. And if it is the reality that a senior counsel will earn more at the bar than by taking judicial office, and if they have commitments, and particularly with the new pension rules, which mean that they will wait 20 years to gather to accrue pension entitlements, when you consider it takes the guts of 20 to 30 years to build up a practice, to study, 5, 6, 7, 8 years of study, 5, 6, 7 years of deviling, building up a practice, by the time one is advanced in a career or reaching a career peak, one is probably 10, 20 years of retirement, usually the former. So these type of pension rules and changes to entitlements actually are an inhibitor from people taking the bar, taking the appointments, and that is something that perhaps should be considered. Another point that should be considered, and it's recognised and it's been amplified in this debate, is the political culture. The political culture that pervades the judiciary now and in recent years, the clashes between, and the separation of powers has not been observed, despite many claims to the contrary. And the government, again, played great lip service to this in recent weeks. The very temerity of any deputy or member of this House or elsewhere to question the government, to question the judiciary. And yet, it is actually the government itself that has led an assault on the judiciary over the last number of years and led to a highly charged atmosphere in which judicial appointments are basically less attractive at this point than they once were. And many judges, it is a fact, many judges, it is an extremely stressful environment and there are difficulties in the position. So the role of judicial integrity and a political perspective, that increasing conflict makes many less inclined to make that leap. And again, if we consider the position of Chief Justice in this bill, it's another needless assault on the highest judicial office. We respect the office. We respect the office of the Ceann Comhairle. We respect the office of the Taoiseach. We bow when we enter the chamber. That is correct. It is proper. It is the office, a high constitutional office, which deserves respect. The Chief Justice is for no other reason than gratuitous inflammation, and this bill reduced to a part player on these judicial committees. It's also true that the Cabinet, even with this bill being in place, the Cabinet can still ignore the recommendations that are proposed. In Deputy Jim McCallaghan's bill, in the Fianna Fáil bill that was introduced, if that were to happen, if the Cabinet was to ignore a recommendation from the Appointments Board, they had to produce good reason. They had to produce a statement to say why. And this bill is nothing of the sort. The bill could pass the House, it could be entered into law, it could be signed in by the President, and we could have the same thing that happened 2 weeks ago could happen all over again. There is nothing in this bill to address the recent controversy, and that's something that I think must be considered by all in the House before we proceed. There is again a potential conflict of interest with the Attorney-General sitting on the board, sitting on the same board that makes the recommendations, and sitting on the same board then that accepts the recommendations. Nemo edicts causa sua, as they would say, at the bench. But that is a clear conflict which is contained writ large into this bill. There are measures against former judges. There are measures against many. I'm conscious of time, but there have been references made in the last couple of days to King's Inns establishment, to practice at the bar, to study at the bar. I think it is worth putting on record that not every applicant that walks into the King's Inns has a silver spoon in their mouth. There are many, including myself, who worked in other walks of life, worked in jobs, who finished a day's work, cycled over to night studies to study at the bar, and indeed I was fortunate to be working in Dublin at the time, which only was a short distance away. studying weekends of a night. There are many who come up from down the country, from Galway, from the west, from all corners of the island. And that traditional route of night study, an evening diploma, and weekend course in the King's Inns is a very valuable piece. And in fact, a former teacher, Jack Lynch, went through the same path. And in fact, there are members of the Supreme Court who did the same. So the idea that the bar is this elitist, unattainable, inaccessible institution is simply untrue.
Deputy Thomas Bourne.